He doesn't deserve no mercy because my mother died a horrible death. She died horrible.
Everything unfolded and I was being blamed as the culprit. No, I didn't get a chance to explain my side of the story.
You still have the opportunity to live a life that this little girl didn't because of you.
On the night of July 20th, 2022, shots were fired outside Lakeview Apartments in Fort Valley, Georgia. During a violent dispute, Christopher Alexander Miller, targeting a resident of Building D, opened fire with complete disregard for those nearby.
At night, Christopher Miller and his friends decided that would be the night that should have been DeQuan Williams' last night on this earth.
One of the bullets pierced a bedroom wall and struck two siblings who were playing inside. The bullet hit Markaylee Ball before fatally striking her brother, Marcus Ball Jr. At the time, both girl and boy were in the arms of their sister. The horrifying event devastated the family and shocked the community. Law enforcement quickly arrested Miller, who was later charged with multiple felonies, including malice murder and aggravated assault. When Miller stood trial in May 2025, the prosecution presented a clear case, backed by eyewitness testimony and evidence. The state also presented emotional 911 calls from that night. Witnesses included Marcus Jr.'s sister, who shared a heartbreaking account of holding her brother as he was shot, and their mother, who tearfully recounted the moment she realized her son was gone.
I blacked out for a minute, but I knew he was already gone. But in my mind, I was coaching myself to think that he was still alive.
Despite challenges in the investigation, such as uncooperative witnesses and initial delays, prosecutors persisted, and the jury deliberated for less than 90 minutes before finding Miller guilty on all counts. The judge sentenced him to life in prison without the possibility of parole, along with an additional 25 years. District Attorney Anita Howard emphasized that the senseless killing of an innocent boy would not be tolerated and reaffirmed the justice system's role in holding violent offenders accountable. In January 2025, 85-year-old Lucy Pat Curl was at her home in Orlando when Ronald Davis approached her, pretending to be a community services officer. After she asked for identification, Davis forced his way inside and violently assaulted her. Lucy sustained critical injuries and, despite medical efforts, passed away on February 5th. Authorities located Davis shortly afterward, sleeping in a nearby shed, and took him into custody. He was later charged with first-degree murder, burglary, assault, and robbery. On April 22, 2025, Davis appeared in court and changed his plea to guilty.
Can you tell me in your own words why you're accepting a plea deal in this case?
When asked in court why he accepted the plea deal, Ronald Davis simply replied that it was the right thing to do. In an emotional and unexpected moment, Lucy's husband, Pastor Bill Curl of First Baptist Church Orlando, stood in the courtroom and publicly forgave Davis.
The defendant has taken from us our patriarch, my wife, 64 years, happily, all the time. She's been the one, the glue that kind of holds our whole family together. And so to you, I would say that for him, we have nothing but forgiveness, for love, for a hope that the rest of his life has better quality.
He spoke not with anger, but with compassion, saying he hoped Davis would find peace and one day come to know God.
Mr. Davis, I rarely see grace in this courtroom, but I saw it today from the Reverend Curl, and you can thank him for this.
The judge, moved by the display, noted that such grace was rarely seen in courtrooms. The judge sentenced Davis to life in prison. The Curl family hopes Lucy's legacy of kindness and strength will continue to inspire their church and community. In August 2023, a drive-by shooting on Poppy Avenue in Orlando turned tragic when shots were fired at the wrong house, killing Ayaliyah Hashim and injuring her mother. The shooting stemmed from a gang-related dispute after 19-year-old Isaiah Wright argued over FaceTime with rivals. He was later killed in the same incident. After ending the call, Wright reportedly said, "Let's go get them," leading to the planned attack. However, the group mistakenly fired at the home next door to their intended target, forever altering the lives of an innocent family.
He stated that Isaiah Wright was arguing on FaceTime with real-lifers, gang members from Carver Shores. When Isaiah got off the phone, he said, "Them boys be tripping, let's go get them." The house that they shot was not the intended target. The house next door was.
Following a months-long investigation, police arrested Tyrick Nichols, Ricky Bowery Jr., along with Nico Brown, who is being charged as an adult.
How do you plead?
On April 25th, 2025, Nichols and Bowery pleaded guilty to 2 counts of second-degree murder with a firearm. In court, prosecutors read a statement from the victim's family, pleading for lasting justice and expressing the depth of their loss.
"I pray justice will be served and these parties will not be able to get out and do this to anyone else. Being behind bars should be for them to think about what they did and how this ruined our families' lives as well."
Over the next 25 years, you can make a decision each day as to who you're going to be and who you're going to be when you get out. You still have the opportunity to live a life that this little girl didn't because of you.
The judge, while handing down the sentence, reminded the defendants that they still have the chance to live a life that Ajalea never will because of their choices. As part of a plea deal, they were each sentenced to 25 years in prison, avoiding trial on first-degree murder charges. On June 22, 2024, Oakland County Sheriff's Deputy Bradley Reckling was fatally shot while conducting surveillance on a stolen Chevrolet Equinox in Detroit. Reckling, a 9-year veteran of the force, had tracked the vehicle, previously reported stolen from Red Oaks Water Park in Madison Heights, to a neighborhood in Detroit. As he followed the SUV in an unmarked car, the suspect suddenly stopped, jumped out, and opened fire. Reckling was struck and later died at the hospital. The 30-year-old deputy left behind a wife, 3 daughters, and a 4th one on the way, devastating the law enforcement community and his family. Following an investigation, 3 individuals were arrested and charged in connection with the murder. One of them, 19-year-old Kareem Blake Moore, pleaded guilty in March 2025 to charges including conducting a criminal enterprise, receiving and concealing a stolen vehicle, and felony firearm possession.
I evaluate the situation as a young man who made some egregious mistakes, but he's not a young man that can't turn his life around, that can't right it.
In court, his attorney claimed Moore had accepted responsibility and could turn his life around, while prosecutors called the sentencing the first step toward justice for Deputy Reckling's family.
This is a family who is still reeling, still raw from the loss of a son, of a husband, of a father, but we are hopeful that by at least starting to turn the page, by getting some forward progress made here, that the process of healing can truly begin and that they can start to find a way to move forward.
On April 26th, Moore was sentenced to serve 5 to 22 years in prison. Trials for the 2 other defendants, Raymond DeBose and Marky Goin, are still ongoing. On April 19, 2025, tragedy struck Los Viejones Barbershop in Fresno, California, when a routine haircut turned deadly. 18-year-old Kobe Chantharangzi, seated under a barber cape, allegedly drew a concealed weapon during an argument with rival gang members and opened fire. The bullets hit 3 people, 2 young men were wounded, while 44-year-old Jean-Pierre Quintero, an innocent father there with his family, was fatally shot. Quintero, according to his wife, died shielding his sons. The next day, police also linked Chantharangzi to another shooting that occurred just hours earlier, where a 19-year-old was hit but survived. Days later, Chantharangzi was arrested, and police also apprehended Adrian Echeverria, suspected of acting as the getaway driver. When Chantharangzi and Echeverria appeared in court, both pleaded not guilty. Chantharangzi's aunt sat silently near the victim's family, not to defend him, but to witness the consequences of a path she had long feared he'd take.
I'm here not to support him, but I just want him to see me. It's been a long time that I prayed for him, scared that he's gonna end up in the wrong crowd and hang out with the wrong friends. When the news came out yesterday, I dreamt of him. And when I woke up, I wanted to text him, but I just couldn't find his last contact. And my friend and cousin texted me and said, "Do you see the news?" And my heart dropped.
She revealed a painful history. His parents abandoned him shortly after birth, and he grew up drifting through trouble, school expulsions, and toxic influences. Despite her efforts to offer support, she said he never never accepted help.
My nephew he's a weak-minded person, and he needs a lot of help. And he's in and out from juvie a lot of times. And I feel like the system doesn't really help him. We're always going to be there for him, but he doesn't want the help. You cannot help a person if they don't want your help. I'm not sad for him. I'm sad for the victim family, you know. 2 kids have to grow up without a dad.
While she expressed heartbreak over his life choices, she firmly stated there was no excuse for the violence. Shantharangzi remains in custody with bail set at $6 million as the case moves forward. On June 24, 2022, Pastor Ronald Mouton Sr., a beloved Houston spiritual leader of over 30 years, was tragically killed in a road rage incident on the Gulf Freeway. While driving home, Mouton reportedly honked and exchanged words with another driver, later identified as 26-year-old Deshaun Longmire. Surveillance footage and Uber records placed Longmire at the scene, and investigators learned he had activated a ride app at the time. As tensions escalated, Longmire rolled down his window and fired a that struck Pastor Mouton, causing him to crash and die at the scene. In the days following the shooting, Longmire was arrested and charged with murder. Further evidence revealed he had tried to purchase a new barrel for his weapon shortly after the incident. Nearly 3 years later, in May 2025, Longmire stood trial in Harris County. During testimony, he claimed the pastor had tailgated and honked at him before the fatal shooting, but the prosecution countered with extensive video surveillance and digital evidence linking him to the crime. The trial concluded swiftly, and on May 1st, a jury found Longmire guilty of first-degree murder.
We, the jury, find the defendant Dylann Longmire guilty of murder as charged in the indictment.
The following day, he was sentenced to 23 years in prison. In court, Longmire offered a brief apology, acknowledging he could not undo what had happened. Pastor Mouton's family, including his twin brother, expressed relief and gratitude for the verdict, finally seeing justice after years of grief. On December 11, 2024, Bill Safaus, a well-known former Channel 19 journalist, was fatally struck while crossing Madison Avenue near his home in Lakewood, Ohio. The driver, 29-year-old Zachary Saliba, remained at the scene and cooperated with police. Investigators later revealed Saliba had been driving nearly twice the speed limit, clocked at around 47 miles per hour in a 25 miles per hour zone. Surveillance footage showed a pattern of aggressive driving leading up to the crash. Safaus was taken to the Cleveland Clinic Fairview Hospital, where he was pronounced dead. His sudden death shocked the community, leaving friends, colleagues, and family heartbroken over the loss of a man remembered for his warmth, humor, and dedication to the field of journalism.
They are so strong, they ripped that tarp sign right off the fencing.
In early 2025, Saliba was formally charged with aggravated vehicular homicide. In court, Safaus' cousin gave a heartfelt statement, expressing the family's devastation and calling for accountability.
My family's been devastated with the loss of Bill, and just because he was in a hurry for whatever reason, he killed my cousin. And I don't know if he cares or not, but I hope he gets plenty of time behind bars to think about what he did.
At his arraignment in May, Saliba pleaded not guilty, and bond was set at $50,000. As the legal process unfolds, Safaus' loved ones continue to seek justice and filed a civil wrongful death lawsuit, accusing Saliba of negligence and reckless behavior, describing the crash as entirely preventable. In February 2025, a suitcase was quietly left near the entrance of Colonel Ledyard Cemetery in Groton, Connecticut. On March 19th, a passerby noticed a strong odor coming from the suitcase and contacted authorities. Inside, police discovered the partial remains of a woman. After forensic analysis, the remains were identified as 58-year-old Suzanne Wormser, who had not been seen by family since December. Concerned about her sudden absence, especially after she missed her sister's birthday, her family reported her missing in mid-April. A witness tip led investigators to Wormser's apartment on Allen Street, where she had been living with 68-year-old Donald Koffel. A search of the residence uncovered key evidence, including traces suggesting a possible struggle.
I assume he got frustrated and snapped. because he didn't want to live there. The property manager told us that Steve told him that, oh yeah, she just gave me the keys and left one day, which, in retrospect, pretty obvious cover.
During initial questioning, Koffel denied involvement, but in a later interview, he admitted to police that an altercation had occurred and that he had taken steps to conceal what happened afterward. Koffel was arrested on April 25th and charged with multiple offenses, including murders and tampering with evidence.
Significant, I don't know if a proper word is grotesque, violent.
Due to medical issues, he appeared in court via video and was held on a $1 million bond. Before the case could proceed to trial, Koffel died on May 9th while in custody at the Corrigan Correctional Center. Authorities reported no signs of foul play, attributing his death to health-related causes. In December 1999, a robbery at the Ale House restaurant on Kirkman Road in Orlando ended in tragedy when Joseph Dungy was fatally shot by off-duty officer John Mina, who later became Orange County Sheriff. Dungy was participating in the armed robbery alongside his uncle, John Jackson Jr., and another individual whose charges were later dropped. During the attempted escape, Mina opened fire, killing Dungy and injuring Jackson. Jackson was later arrested and, after accepting a plea deal, was convicted of second-degree murder, armed robbery, and burglary. He was sentenced to prison, where he has remained for over 2 decades, with a release date set for 2031. In 2024, Jackson petitioned for a new trial, arguing that his original defense was inadequate and that new evidence. As part of his efforts, he testified and introduced a new witness, Dwayne Miller, who claimed Jackson was wearing different clothing than described by police and was not directly involved in the robbery's most violent moments.
What did you do with your pants?
I mean, it was obviously thrown away.
You destroyed evidence?
Now it's a problem?
Did you destroy evidence? At this juncture, you're in cover-up mode.
When everything unfolded and I was being blamed as the culprit, I didn't get a chance to explain my side of the story.
However, the state countered with a jailhouse interview Jackson gave to a channel in 2023, highlighting contradictions between his public statements and courtroom testimony.
Meaning, you had some prior knowledge of their plans to commit a robbery.
No, that's not what I told Channel 2 News.
According to your interview with Channel 2, the office door fly open.
Yes, ma'am.
Because it made a bang.
The judge ultimately ruled against Jackson, rejecting both his and the new witness's claims as lacking credibility. With his motion denied, Jackson's attorney signaled that an appeal is unlikely, though the legal window to do so remains open for 30 days. In the early morning of November 12, 2023, Jacksonville Corrections Officer Cassius Barry Edwards was involved in a high-speed crash on Lane Avenue South that tragically claimed the life of another driver. Investigators later confirmed that Edwards was driving under the influence, with a blood alcohol level more than twice the legal limit. He sustained non-life-threatening injuries in the collision. The Jacksonville Sheriff's Office responded swiftly by suspending him without pay and removing his law enforcement authority. Sheriff T.K. Waters called the incident devastating and reaffirmed the agency's commitment to accountability, stating no one is above the law. Edwards was arrested and charged with DUI manslaughter and vehicular homicide.
All right. Your Honor, Cassius Edwards stands here before you today as certainly a lifelong citizen of Jacksonville, Florida. He has 2 young children. He also is his primary caretaker for his kids as well. He's a corrections officer with JSO as well. And certainly, seeing how serious the charges are here, we want to, see how to mitigate the actual bond amount so that it's not tantamount to no bond, set at a reasonable cost, and certainly protecting the public, certainly, with respect to driving alcohol. So.
Okay, I appreciate that. These bonds were set by another judge, Judge Sachs, who's our circuit court judge.
Understood.
So I will respect the bonds he set in the warrant. Obviously, you can file a motion at that time whenever you wish. Okay, but
excuse me, will it go to Judge Thatcher as well?
Yeah, it should go. Oh no, it's not. Hold on, who is it going to? I think the clerk will know who that goes to. This is Mr. Cassius Edwards. Do we know who it will go to? We don't? Okay, we don't.
You don't know yet?
We don't know yet. It'll go to someone though. It won't go to me, I can tell you that.
We have a date.
But we do have a date. So it looks like that felony date is gonna be 12/13.
12/13, okay.
And then again, obviously probable cause was found by warrant. I will just go ahead and put on the record what these bonds are, even though they're already in the warrant, but it's 100,003 for count one, no alcohol or drugs, a scram patch, and then scrammer patch were both, and then also count two was 100,003. Again, that's for the vehicular homicide, no alcohol or drugs, scram patch or both, no driving. Mr. Edwards, you need anything else from me other than what we've gone through?
No, sir. Appreciate it.
Very good. Thank you, Mr. Smith.
Thank you.
Anything else for me?
One last, December 13th.
Yes, sir.
Thank you, Your Honor.
Thank you.
Can I be excused?
Yeah, of course. You have a good one.
His bond was set at $100,000 for each charge. In a court appearance later that month, Edwards pleaded guilty to both charges. He was sentenced to 8 years in state prison, followed by 2 years of community control and 4 years of probation. On the morning of November 14th, 2023, a devastating crash unfolded on Interstate 70 near Etna, Ohio. A charter bus carrying students and chaperones from Tuscarawas Valley local schools was on its way to a conference in Columbus when traffic slowed due to an earlier crash ahead. At that moment, Jacob McDonald, a 61-year-old truck driver from Zanesville, was operating a 2019 Freightliner semi-truck. He failed to slow down in time, resulting in a catastrophic 5-vehicle pileup. The collision claimed 6 lives: 3 students, John Mosley, Jeffrey Worrell, and Caitlin Owens, a teacher, Dave Kennett, and 2 chaperones, Christy Gaynor and Shannon Wigfield. Additionally, 18 other people were injured. The incident shocked the community, prompting grief, vigils, and calls for justice.
Let me just briefly discuss the counts. 26 counts in total. Counts 1 through 6 charge the defendant with aggravated vehicular homicide with respect to each of the 6 fatalities. Those counts charge the defendant with recklessly operating a motor vehicle causing the death of another person. Counts 7 through 15 charge the defendant with vehicular assault. In each of those counts, the defendant is charged with causing serious physical harm to another person as a result of recklessly operating a motor vehicle. Counts 16 through 20 all charge the defendant with assault. These charges are based on the assertion that the defendant knowingly caused physical harm to another person.
Jacob McDonald was charged with 26 counts, including aggravated vehicular homicide, vehicular assault, and assault. Prosecutors argued that he was distracted, possibly by his cell phone, and driving negligently, while the defense disputed the reliability of the cell phone evidence and denied reckless behavior. The bench trial concluded in May 2025, presided over by Licking County Judge David Brandstuhl.
You know, this job gives me the opportunity to recognize how at various points in our life, we're all just a few feet or a few seconds away from a disaster. And that's what happened here. The facts of the case are largely undisputed. November 14th, 2023, between 8:47 a.m. and 8:48 a.m., a fatal crash involving 5 vehicles occurred on Interstate 70, approximately 0.2 of a mile west of milepost 119 here in Licking County. At the time of that collision, traffic had slowed due to a crash that had occurred approximately 1.5 miles ahead. There's no dispute in this case that the 2019 Freightliner driven by the defendant struck the rear of the vehicle in front of it. That vehicle was pushed into the rear of the vehicle in front of it, and so on. Counts 1 through 6 and 7 through 15 all allege that the defendant acted recklessly in his operation of his vehicle, and that reckless operation caused the death, as alleged in counts 1 through 6, or the serious physical injury, as alleged in counts 7 through 15. Recklessness is defined in Ohio law as follows. A person acts recklessly when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or is likely to be of a certain nature. A person is reckless with respect to circumstances when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. Negligence is defined as follows. A person acts negligently when, because of a substantial lapse from due care, the person fails to perceive or avoid a risk that the person's conduct may cause a certain result or be of a certain nature. A person is negligent with respect to circumstances when, because of a substantial lapse from due care, the person fails to perceive or avoid a risk that such circumstances may exist. I find that Mr. McDonald is criminally responsible for this accident, this collision. However, I find that the state has failed to establish beyond a reasonable doubt the element of recklessness. There was a lot of argument and evidence centered around the data from the defendant's cell phone. Frankly, I did not find the evidence regarding the data from the cell phone to be convincing. Because I find that the state has failed to meet the element of recklessness, I'm going to enter a not guilty verdict on counts 1 through 6 and 7 through 15. However, I will enter guilty verdicts on the lesser included offenses to counts 1 through 6, which are vehicular homicide, violation of revised code section 2903.06 A3A, which is based on his negligent operation of the vehicle. Count 7 through 15, frankly, they're based on a higher mens rea or mental element than even recklessly. And because I find the state has failed to establish the element of recklessness, the evidence is insufficient to establish that he knowingly did this.
After reviewing testimony and evidence, the judge found McDonald guilty of 6 counts of misdemeanor vehicular homicide, concluding that while McDonald had acted negligently, his behavior did not meet the legal threshold for recklessness required for the more serious felony charges. As a result, he was acquitted of the felony counts related to both the fatalities and injuries. Judge Brandstuhl acknowledged the pain of the families and the tragic consequences of McDonald's failure to exercise due care, but emphasized the distinction between negligent and reckless conduct under Ohio law. McDonald's sentencing is pending, with a potential maximum jail term of 18 months. On the morning of December 2nd, 2017, 21-year-old Jared Plisek, a beloved Salvation Army youth worker and Bible study leader, was getting ready to begin another day of volunteering. Wearing his uniform and holding his Bible, he stood in the lobby of his apartment building in the Collinwood neighborhood of Cleveland, Ohio. It was there that 27-year-old William T. Jones approached him. Without warning or provocation, Jones pulled out a firearm and shot Plisek. him instantly. Policex, known for preaching compassion and helping young people in troubled neighborhoods, became the victim of what would be described as a senseless and brutal act of violence. Immediately after the murder, Jones fled the scene and began a violent spree across Cleveland and into Lakewood. He attempted several carjackings, successfully stole multiple vehicles, and shot a woman during one of the encounters. His actions led to widespread fear throughout the community until police apprehended him later that day in Lakewood. Jones was indicted on 35 charges, including aggravated murder, felonious assault, aggravated robbery, and numerous firearm specifications. In April 2018, he pleaded guilty to all counts in a deal that spared him the death penalty. On May 21st, 2018, Cuyahoga County Judge Stephen Gall described the murder as a random and senseless act of violence that shocked even those familiar with the darkest corners of the justice system.
All right, Mr. Jones, I'll be honest with you, that's not too often I find myself in my life that I'm at somewhat of a loss of words. To begin with, I would submit to you that all lives matter. Not just black lives, not just Asian lives, but all lives matter. As I pondered this sentencing over the weekend, I tried to myself make some sense of it. Those of us, I think, who work in this system tend to see the worst in society, and sometimes we get a little desensitized to those types of offenses. And then there comes a situation like this that comes around maybe once in a great while. It's really hard to wrap your head around, at least for me. When you talk about a senseless act of random violence, there's really no other words that come to my mind that describe this. I think senseless violence is almost by definition hard to understand. And somehow to attempt to justify the taking of Jared's life is really incomprehensible to me.
During the sentencing, Jones offered no remorse. Instead, he delivered a statement referencing racial injustice and social inequality, remarks the judge found completely disconnected from the devastating crimes he had committed.
With respect to the firearm specifications, the court finds that the 1 year, 3 year, and 54-month firearm specification on each counts 1 through 21 would merge into a single 54-month specification for that particular count. And pursuant to revised code section 29.14B1E, I will dismiss the 1 year firearm specification on count 34. Court finds that the 5 year firearm specification in counts 12 through 21 would merge. After considering the overriding purposes and principles set forth in sections 29.11, I do find the following and impose the following sentence. As to count 1, the 54-month on the firearm specification to run prior to and consecutive to a sentence of a life without the possibility of parole sentence. As to count 3, 54 months on the firearm specification to run prior to and consecutive to a sentence of 9 years. As to count 4, 54 months on the firearm specification to run prior to and consecutive to a sentence of 9 years. As to count 5, a 54-month sentence and the firearm specification to run prior to and consecutive to a sentence of 9 years. As to count 6, 54 months on the firearm specification to run prior to and consecutive to a sentence of 9 years. As to count 9, 54-month sentence on the firearm specification to run prior to and consecutive to a sentence of 36 months. As to count 10, 54 months on the firearm specification to run prior to and consecutive to a sentence of 6 years. As to count 11, 54-month firearm specification to run prior to and consecutive to a sentence of 6 years. As to count 12, be 54 months on the 54-month firearm specification to run prior to and consecutive to 5 years on the 5-year firearm specification to run prior to and consecutive to a sentence of 10 years. As to count 13, 54 months on the firearm specification to run prior to and consecutive to a sentence of 6 years. As to count 14, a 54-month sentence on the firearm specification to run prior to and consecutive to a sentence of 6 years. As to count 15, a 54 months on the firearm specification to run prior to and consecutive to a sentence of 6 years. As to count 16, 54-month sentence on the firearm specification to run prior to and consecutive to a sentence of 6 years. As to count 22, be a 24-month sentence. As to count 23, it'll be a 12-month sentence. As to count 24, it'll be a 12-month sentence. As to count 25, be a sentence of 24 months. The court also imposes a lifetime suspension upon your driving privileges. As to count 26, a sentence of 24 months. As to count 27, a sentence of 12 months. As to count 28, a sentence of 24 months. As to count 29, a sentence of 12 months. As to count 30, a sentence of 10 years. As to count 31, a sentence of 8 years. As to count 32, a sentence of 180 days. As to count 33, a sentence of 90 days. As to count 34, a sentence of 36 months. I will run the sentences in counts 3 and 5 concurrent with each other but consecutive to all their counts. The sentences in counts 4 and 6 concurrent with each other but consecutive to all their other counts. I will also run the sentences in counts 32 and 33, the 180 days and 90 days respectively, concurrent with all other sentences. In this situation, I do find that a consecutive sentence is necessary to protect the public from future crimes or to punish you, and that consecutive sentences are not disproportionate to the seriousness of your conduct and to the danger, truly, the danger that you pose to the public.
He sentenced Jones to life in prison without the possibility of parole, plus over 200 years for the additional offenses committed during the crime spree. Friends, family, and fellow churchgoers remembered him as a kind, faithful young man who dedicated his life to serving others. In March 2025, a quiet Amish community in Rutland, Ohio, was shaken by the discovery of a gruesome crime. On March 13th, 28-year-old Rosanna Kinsinger was found dead in her home on Dye Road. Concerned after not seeing her throughout the day, a fellow community member, Mose Troyer, entered her home and discovered her body. Notably, her pet goat was also found inside. The Meigs County Sheriff's Office immediately launched an investigation, and her body was sent to the Montgomery County Coroner's Office for an autopsy, though early results were inconclusive. The case quickly gained traction. After executing search warrants and conducting multiple interviews, detectives identified 18-year-old Samuel Hochstetler as a key suspect. Originally from Kentucky, Hochstetler had recently been staying with Mose Troyer, the very man who discovered Kinsinger's body. On May 5th, 2025, following an interview with detectives, Hochstetler was arrested and formally charged with Rosanna Kinsinger's murder. On May 13th, 2025, Hochstetler made his first court appearance.
State of Ohio versus Samuel Hostetler, CRA 25-145. Counsel in the courtroom, if you would please identify yourself for the record.
Yes, Your Honor, thank you. James Stanley, Mexican prosecutor here in the state of Ohio.
All right, please report directly on 116 Marbury Avenue, Courtroom, Ohio, representing Mr. Samuel Hostetler.
Thank you very much. Gentlemen, we're here today on a matter with Mr. Hostetler on about May 6, 2025, filed in the Meigs County Court on about May 6, 2025. This complaint alleged on or about 12 March 2025 in Meigs County, Ohio. Mr. Hostetler did violate Ohio Revised Code Section 2903.02, murder, an unclassified felony. Mr. Hostetler was previously arraigned in this court. A bond of $1 million cash was set to secure his appearance here today. Mr. Cleland was appointed counsel. And the purpose of our hearing here today, of course, is a preliminary hearing regarding this allegation. Trent, here in front of me, I have what appears to be a waiver signed by Mr. Hostetler. Is that your client's intention?
That is correct.
All right. Mr. Hostetler, I have here in open court, so you're sitting here, and I have by phone a Thomas Beachy, correct, Mr. Beachy?
That is correct.
Okay. I was advised potentially that in addition to English, you spoke Pennsylvania Dutch. Okay, so I made arrangements to have an interpreter join us here today for this hearing. Do you feel that you can proceed here today in English, or do you wish Mr. Beachy to be here to interpret for you in Pennsylvania Dutch? Okay. Do you wish him to remain here on the line with us?
If it's not too hard.
Okay, well, we've got him here, so we'll use him, okay? All right. So, Mr. Beachy, what I'm going to suggest is if you would simply listen to what I say, and if Mr. Hostetler has any trouble understanding, perhaps you could explain that to him in Pennsylvania Dutch. Would that be okay?
That would be perfectly satisfactory. The interpreter will wait until he is prompted for help.
Thank you very much. James, is that all right with the state?
Yes, sir.
Trent, I'll let you finish. Very well. Okay, so Mr. Hostetler, you understand what you're charged with, correct? Okay, you met with your attorney before coming here to the courtroom, correct? Yeah, okay, all right. You understand you have a right to a preliminary hearing this afternoon, and further, you understand that I have in front of me what appears to be a waiver of that right here this afternoon, correct? All right, I'm going to ask you here in open court, sir, is that your signature on the waiver?
I can't really read it. I'm pretty sure it's the paper you had.
Okay, well, I want you to look at it and just confirm that you did sign that document. Okay.
Is that your signature?
Okay, thank you, Trenton. Thank you, sir. All right, so Mr. Hostetler, based upon the fact that you've had a chance to talk to counsel here this afternoon, I'm going to make a finding that with full knowledge of your rights and voluntarily here today, you are waiving your right to this preliminary hearing. Do you understand that? All right. Furthermore, your case is going to be bound over here to the common pleas court for further consideration by its grand jury. Do you understand that?
Not sure.
Okay. So what's going to happen is your case is going to be bound over to this court, to the common pleas court, where your case can go to grand jury to be considered for indictment, or it can proceed directly in front of Judge Warner. Do you understand that? Okay. James, do you desire any further inquiry regarding Mr. Hostetler?
No, Your Honor, thank you.
All right. Trent, do you desire any further inquiry of your client?
Nothing further, Your Honor. Thank you, sir.
All right. The bond is previously set. $1 million shall continue. Anything else, James, on behalf of the state of Ohio?
Nothing from the state, Your Honor, thank you.
Trent, anything more on behalf of your client?
Nothing further, Your Honor.
Okay. Mr. Hostetler, we're all done here this afternoon. Thank you for being here. Mr. Beachy?
Yes.
With that, we will be all done. You have my contact information. Please send me an invoice for your services, okay?
Thank you, Your Honor. The interpreter will do that.
Thank you very much, sir. I'm going to hang up.
Though an interpreter fluent in Pennsylvania Dutch was present via phone, Hochstetler, who is Amish, indicated he could proceed in English. He formally waived his right to a preliminary hearing, allowing the case to move forward directly to the Meigs County Common Pleas Court for grand jury consideration. 10 days later, on May 23, 2025, Hochstetler was arraigned and entered a plea of not guilty. He now faces multiple serious charges, including aggravated murder, kidnapping, and strangulation. The indictment also includes sexual motivation and violent predator specifications, charges that, if upheld, could result in a mandatory life sentence without the possibility of parole. The Amish community has been left reeling. Rosanna Kinsinger was remembered as a bright and kind-hearted individual. Her father, Moses Kinsinger, shared a message of forgiveness, saying, "Through God, there is forgiveness," despite the pain the family endured. As of now, Hochstetler remains in custody on a $1 million bond. A pretrial hearing is scheduled for June 27, 2025. On November 19, 2023, Christopher Terry, age 40, was driving a 2019 Dodge Challenger at an extremely high speed, over 120 miles per hour, through a residential area in Cleveland's Mount Pleasant neighborhood. As he raced down East 139th Street near Kinsman Road, he lost control of the vehicle. The car crashed through multiple yards and trees before colliding with the porch of an apartment building. The impact ruptured a gas line, triggering an explosion that destroyed the building. Tragically, 69-year-old April Yarbrough, who had recently moved back to Cleveland, lost her life. Terry fled the scene, prompting a weeks-long search. He was eventually captured on February 16, 2024, by the U.S. Marshals Northern Ohio Violent Fugitive Task Force. He was indicted shortly after on charges including involuntary manslaughter, vehicular assault, tampering with evidence, and leaving the scene of a crash involving property damage. His trial began in January 2025, and on January 21st, he was found guilty on all charges. At the sentencing hearing on March 3rd, 2025, April Yarbrough's son gave a moving statement, sharing how her death left a permanent void in their lives.
I can just say that the death of my mother have totally left a void that can't be healed. Her death was not an accident. It was not an accident. It was a result of a deliberate act of recklessness, a choice the defendant made. His total disregard for the law, the lies he tried to cover up his crimes, is totally it's beyond comprehension. I understand that the court considered many factors when deciding sentences, but I ask for no leniency. I ask for no mercy, because his choices have affected me and my brother and my entire family. Granting leniency would totally disrespect my mother's memory. Excuse me.
How old was your mother at the time?
69. 69. She had just moved here. We all were in Atlanta. We are originally from Cleveland. She moved back. My brother moved back. My brother moved back. She moved back. But she hadn't only been here for 30 days trying to get her feet back on the ground when this happened. Since it was act totally unnecessary for a flex of a Hellcat. It's not necessary. I understand. I have one of those cars. I understand the allure of it, but there's a time and a place for everything. And the defendant should be old enough to know where that place is. He's not 20. He's not 30. He's older. He has a history, and I pray that you consider that history. And I feel sorry for his family, because for someone his age, they shouldn't even be in the courtroom. And I'm not trying to directly talk to him, but I'm just addressing him on my heart. He doesn't deserve no mercy at all. because my mother died a horrible death. She died horrible. Nobody in this courtroom would want their mother to die in that fashion. We deserve the right to bury my mother, at least with an open casket, man. And it was not possible. So I just ask for no mercy, and please forgive me for my emotions, but this is very challenging.
Of course.
So thank you for giving me a hearing.
Unable to have an open casket funeral due to the severity of the incident, the family was left with no proper way to say goodbye. He asked the court for no leniency, saying any mercy would dishonor his mother's memory. Judge Ashley Kilbane echoed the family's pain in her remarks, calling Terry's actions among the most reckless she had ever seen. She emphasized the extreme danger of driving at such high speeds in a residential area and noted Terry's long criminal history, which included drug-related offenses and multiple violations of probation. At the time of the crash, he was already under federal post-release supervision.
I find it incomprehensible that somebody could even reach those types of speeds in a residential neighborhood, and it makes absolute sense why one would then lose control of a vehicle in such a space. So, having considered the purposes and principles of sentencing, I'm finding that you are not amenable to a community control sanction. You have not done well in the past on community control sanctions. You are on release from the federal courts and from the federal prison system at this time, and you have a history of noncompliance with the law, including traffic laws and driver's license laws. So I am going to sentence you in this case on count 4, the felony of the 3rd degree, 36 months in prison, and I have to determine a sentence on count 1, which is involuntary manslaughter. And what we do when we look at involuntary manslaughter, we look at, in all cases, the nature of the offense, the purposes and principles of sentencing, recidivism rate. We look at all of the factors, and I have to determine, is this the most serious form of the offense, or what is the manner of this offense? And count 2 merges into, but the manner of this was one of the most, if not the most reckless operation of a vehicle, complete disregard for any human life. We're talking about a residential neighborhood in the middle of the day when there could be children outside playing, crossing the street. It is as reckless as it gets to drive a vehicle over 100 miles per hour in a residential neighborhood. So I am finding that this is one of the more serious forms of the offense for the manner in which this involuntary manslaughter happened. So I'm going to sentence you in this case on count 1 to 6 years incarceration, and I'm going to run it consecutive to your felony of the 3rd degree. I'm finding that consecutive terms are necessary to punish you and protect the public from future crime. They are not disproportionate to the seriousness of your conduct and to the danger that you pose to the public. You're in that vehicle. I believe, the jury believes, and common sense dictates that you were driving that vehicle in a manner so reckless as it is unimaginable that you didn't kill anybody else, only to sheer luck that they weren't standing there on their tree lawn. That is just sheer luck. One or more of the offenses were committed. You were on post-release control from the federal government, so I'm making that finding, and 2 or more offenses were part of 1 or more courses of conduct. So you knew what had happened, and you decided to try to hide it from not only the police and this community, but also the victim's family in answering what happened to their loved one. And so I am, and then as for your record, you have a criminal history that demonstrates that consecutive sentences. You have a history of alcohol, driving incidents, and then on top of it, drug. You have been trafficking drugs, having possession of drugs to the point where there's multiple convictions for this, and every single time you've been given an opportunity on probation, or most of the times, if not all, you have not demonstrated your ability to be rehabilitated in the community. So I am making those findings. I'm going to explain the indefinite sentencing here. So The Ohio Department of Corrections, you are eligible for anywhere between 5 to 15% relief from your minimum sentence. If you are not recommended for early release, there's a presumption that you'll be released after serving your minimum term. However, if you are not recommended for or denied early release, there is then again, there's a presumption that you'll be released at the end of your minimum term. The Ohio Department of Corrections will hold a hearing. There's no involvement in the court and whether or not you were released through your maximum term. If you are released through your minimum term, there is a post-release control obligation here. It's a mandatory minimum of 2 years up to a maximum of 5 years in which the parole board will monitor you, and I'll explain the penalties if you violate in this instance. There may be more than one hearing in regards to whether or not you'll be maintained in prison through your maximum term. You can be denied early release, or release after your minimum term, or release through your maximum term if any of the following apply. You are classified at a security level 3 or higher. You are placed in extended restrictive housing at any time during the year preceding the hearing. You violated institutional rules that compromise prison security or the safety of staff or inmates, or that involved physical harm or threat of physical harm to staff or inmates, or committed a violation of law that was not prosecuted, and that those infractions or violations demonstrate a lack of rehabilitation. Your behavior while incarcerated demonstrates a continued threat to society. You did not productively participate in a majority of the rehabilitative programs and activities recommended by the DRC, or did not successfully complete a reasonable number of the programs in which you participated. Or upon release, you will not be residing in a halfway house, reentry center, or licensed community residential center, and do not have any other fixed address at which to reside, essentially being homeless. So I'll calculate your jail time credit. You have, your sentence is 9 to 12 years in prison. And again, upon your release, you will be monitored at least for 2 years up to a maximum of 5 years. If you violate any of the terms and conditions of post-release control, you can be sent back to prison for up to 1/2 of any sentence that I give you, or up to 9 months for any single violation. You do still have your federal case. I cannot control what the federal judge will do in regards to your violations there, but this is the sentence of the court. I've discussed with the attorneys prior to going into the record regarding the request for restitution. We are going to have some further briefing on the specifics of that and a restitution hearing later if necessary. Is there anything else for the record?
No. Terry was sentenced to a total of 9 to 12 years in prison, 6 years for involuntary manslaughter, and 3 years for vehicular assault, to be served consecutively. After his release, he will be subject to mandatory supervision for at least 2 years and up to 5. A separate restitution hearing for the victim's family is expected. For April, Yarbrough's loved ones, the sentence offered some sense of justice for a loss they will carry forever. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.